Hey folks, welcome back to the channel. Today's hearing is heartbreaking. A child died from a methamphetamine and cocaine overdose. Who's to blame? Their mother. She carelessly left them in the same hotel room where she was living with her children. Prosecutors claimed she was running drug deals, and the court is now deciding if she should be released on bond or remain in custody while the process continues.
Is this Ms. Kuykendall? Okay. Can you speak up? I can't hear you very well, Ms. Kuykendall.
It's Kuykendall, Your Honor, and I would just like to announce that we would be waiving the sounding of the charges this morning.
Okay. Kuykendall it is. And you are Ms. Steffo?
Yes, good afternoon, Your Honor.
Let me get you on the screen, get Ms. Wood off. Okay. Mr. Rao, are you handling, this is a bond hearing. This is an unindicted case. I actually met Ms. Kuykendall when I was presiding. She was brought over, but we didn't have an attorney to represent Ms. Kuykendall. There was an attorney for her co-defendant, Mr. McCaslin, from the Public Defender's Office. So they had a conflict and could not represent Ms. Kuykendall for purposes of the bond hearing. Will you be handling this one, Mr. Rao?
Which case is this, Judge?
It's on the bond hearing calendar that Ms. Nelson published about a week ago. Ms. Kuykendall and Mr. McCaslin are both listed on it. It's something that I don't remember if you covered it. It might have been a different unit. The victim, the deceased, is a minor. So that could be a different unit in your office.
Your Honor, if I may, I believe that ADA McCauley, with the Cobb County's District Attorney's Office, they're actually going to be handling this case.
Right.
I'm sorry for interrupting.
No. You're exactly right. I remember when I heard about this from Ms. Nelson, I was confused, but that may explain why Mr. Shapiro was on. So I'm going to put him on the spotlight. Look at that. He's wearing a Cobb County tie.
Judge, it's not Mr. Shapiro. Can you pin me to the case, please?
Oh, is he just watching you do your thing?
Yeah, we have the whole squads on, actually.
All right.
Cobb County.
He just went away. They're going to learn how to do bond hearings in Fulton County?
No, I think they're just curious because they're all very excited about having two people joining their team. So
great. All right. Well, Ms. Kuykendall, we didn't get to do the bond hearing when we were supposed to, through no one's fault. You're just entitled to an independent lawyer who isn't a direct colleague of the lawyer who represents Mr. McCaslin. So we're doing now what ideally we would have done at that earlier calendar. Ms. Steffo, I am ready to hear from you in one moment. I need to understand, Ms. McCauley, why it is that your office is handling, I'm assuming it's the entire case insofar as this results in an indictment. So both defendants, not just Ms. Kuykendall.
yes, that is correct, Judge. There was a conflict within the Fulton County District Attorney's Office. So the case was then wheeled to the Prosecuting Attorney's Council, and Cobb County District Attorney's Office was appointed. Because it is a child fatality, it will be handled by the Special Victims Unit in Cobb County. And I am appearing on behalf of the Special Victims Unit in Cobb County.
Great. I appreciate your office taking the case and you making time to do this. Will you be the ADA assigned to it, or that's a TBD, depends if it's indicted, et cetera?
Well, I'm actually extremely familiar with this case because when I was still working in Fulton County, I actually handled the preliminary investigation along with College Park Police Department. It will be myself, ADA Shapiro, ADA Lush, or ADA Rayner, maybe a combination of the four of us that will be handling this case through indictment. We've already obtained everything from the Fulton County District Attorney's Office and are working with the agencies to complete the investigation and intend to present it to the grand jury before the 90th day, which I believe is in February.
Okay. Thank you for that update. Then we ought to be able to go forward. Ms. Kuykendall, the only thing we're going to work through today is bond. Ms. Steffo in a moment is going to share with me why she thinks you're entitled to bond. I will hear from her. And when I'm done hearing from her, I'll turn to Ms. McCauley. She will share with me the state's perspective as to whether bond makes sense, and if not, why not. I don't think there'll be any people speaking on behalf of the deceased, because I think that would be you or Mr. McCaslin, but the state is always free to present evidence of family members who've got a perspective, or people connected with the victim who have a perspective on bond. I suspect it'll just be the two lawyers who are working through this. Ms. Steffo, when you're ready. You're on mute.
Sorry, Judge. Ms. Kuykendall is 32 years old. She's born and raised in Atlanta, and her entire family is here, including all 11 of her siblings who she's very close with. She had 4 children, but she does have 3 children. Madison, who's 13 years old, Jakaya, who's 10, and Legacy, who's 1. Currently, her kids are with her father and their godmother. She does have her GED, and she was working prior to this. She was doing DoorDash as often as she could, and she was doing hair on the side. The address that's on file with the court is a good address. I have confirmed that she will be living there with her godmother, Miss Brenda Finch. She has very limited criminal history, so there's no likelihood to reoffend. She, from my understanding, only has a misdemeanor criminal history, no felony convictions or felony pending charges against her as of right now. The reason that she was staying in the hotel that maybe mentioned was because she was working on getting an apartment for her and her kids. She's been saving up money so that she can provide for her children, and then focus on her career with hair more so than relying on the DoorDash judge. So we are asking for a bond in this matter for both counts not to exceed $50,000, and we are willing to be on an ankle monitor with the exceptions of work and any legal meetings or medical requirements.
Okay, thank you for that. A couple questions. You mentioned that the 3 children were with Ms. Kuykendall's father and godmother, and then I heard you say that Ms. Kuykendall might be staying with the godmother. Is that the same person? And if so, does that mean Ms. Kuykendall would be staying where the kids are? And is that something, I don't know if you and Ms. McCauley have been talking at all about this case, but given these charges, having Ms. Kuykendall being in the same household as the kids strikes me as a potential source of concern. And so if that was your vision and Ms. Kuykendall's vision, I'd like you to address that for me.
Yes, Your Honor. So she would be staying with the same godmom. I do understand the natures of the charges. It does present an issue to the court. I do understand also that the children are having a very hard time without their mother, and they want their mom to come home. They don't really understand what's going on, and it's been a really big struggle for them. And I do believe that Legacy is 1 year old, and so I believe he was breastfeeding at the time. And I know that that's been a hard adjustment for him to have to be switching. He relies on his mother, and so it was the intention to have her stay with the godmother and be reunited with her children.
Related to that question, you mentioned that the 3 children were with Ms. Kuykendall's father and godmother. Are they in the same household, or does that mean that, for example, the oldest child is with Ms. Kuykendall's father and the other 2 are with the godmother?
My understanding is the oldest child is with the father, and the younger children are with godmom.
Okay, and it's the godmother's home where you're envisioning Ms. Kuykendall staying?
Yes.
Okay, and tell me your understanding of Ms. Kuykendall's connection in terms of parentage, relationship, et cetera, with Mr. McCaslin.
That is her significant other. They've been on and off for 5 years, and they did share the child that passed away. They shared that child together, and they do share Legacy, the 1-year-old child, together.
Okay, got it. All right, thank you so much. Ms. Smith-Mann, good afternoon. Thank you for joining us from pretrial. Can you share any criminal history information you have for Ms. Kuykendall?
I sure can, Your Honor. There are 5 cycles. Last arrest was on 6/6/19. ATL, theft by deception. That case number is 20 CR 0028134. There are no felony convictions. There are 2 misdemeanor convictions. Nothing further, Your Honor.
Thank you so much.
You're welcome.
Ms. McCauley.
Yes, I'm going to provide a brief overview of the facts. I won't go too far into the facts because we are not here.
I'm sorry, you're hard to hear. I don't know if something changed with the microphone.
Do I need to?
No, that's good. You're good now.
Okay.
Now you're good.
I just need to speak up. That's okay, Judge. I'm going to give a brief overview of the facts because I think some of them are relevant to the factors of bond. So this child's death results from the drug overdose on methamphetamine and cocaine that was inside the hotel that the defendant and her co-defendant were residing in. On the day of the homicide, following College Park Police Department's investigation, there were text messages that were located on this defendant's phone of her engaging in active drug transactions for both marijuana and crack cocaine on the day of the homicide. I would be happy to show those to the court. Prior to this child's death, this child overdosed on THC back in July of 2024. There were also text messages recovered off of her co-defendant's phone and this defendant's phone about making sure that neither party disclosed to the Division of Family and Children Services the nature of the child's ingestion of that THC, and also a refusal from both parents to test positive for that THC. And that is documented. Again, the state would be happy to share screen those text messages to the court for the court's review.
You just said something that confuses me. I'm sorry. You said that both Mr. McCaslin and Ms. Kuykendall refused to test positive. They refused to take a test when there was a concern about what's going on, or I didn't follow that.
They declined to provide DFACs with the correct information of how this child ingested THC, which is documented in the text messages, that they were aware that it was THC. They were aware of how the child got a hold of it. And they said, make sure, actually it was Ms. Kuykendall to Mr. McCaslin, make sure you don't tell DFACs that there's anything in your system. Never admit that to DFACs or anyone else. And then upon review of the DFACs records, both parents said they would not need to take and did not want to take a drug test.
Okay, that was the part I didn't get. Thank you.
Sure, of course. So there was a prior DFACs case involving an overdose, and then the drug activity continued to occur between the co-defendants of selling and distributing narcotics, methamphetamine, cocaine, and marijuana over the course of, I would say, I have at least 6 months of text messages, and they're very actively engaged in hand-to-hand drug transactions. There is also 2 undercover operations that were done by the College Park Police Department, which indicate they were both selling actively while they had these 2 children living in this hotel room and exposing them to their narcotic activity. As it relates to the defendant's criminal history, I have a conviction from 2010 out of Clayton County for disorderly conduct, obstruction, and possession of marijuana. I have a case out of Clayton County from December of 2015 for driving on a suspended license, a theft by shoplifting out of Clayton County from July of 2017. Then I have a DUI that was reduced to a reckless driving out of Cobb County in September of 2021, and then a probation violation in Cobb County as well that followed that DUI or reckless driving conviction. I did not have the theft by deception case out of Fulton County, but I do have more than just one interaction for this defendant with law enforcement, and certainly at least one probation violation. As it relates to the Ayala factors, the defendant has demonstrated, 1, that she poses a risk to the community based on the prior overdose of the child, and then the condition in which the condition and circumstances of this child's death. She was actively engaged in drug trafficking and drug transactions at the time of this child's death. There's a risk to victims and witnesses should she be permitted to be released, and that risk is to the surviving children. There is also some indication that in between this child's death and law enforcement becoming notified by Children's Healthcare of Atlanta and becoming involved, that a family member went into the hotel room and cleaned out the hotel room. There is some surveillance footage that gives rise to that issue during the pendency of this case. And then she does pose a risk of returning to court based on the probation violation. And the steady interactions, I think, with law enforcement also indicate a lack of willingness to follow the laws and return to court as needed. As it relates to her ties to the community, the state does not have anything to disprove that Ms. Kuykendall is not based in Atlanta or doesn't have significant ties to Atlanta. So based on all of those factors, Your Honor, and all of this information, the state would request that the court deny bond.
If I'm remembering correctly, and it's been a little while, when we had the bond hearing for Mr. McCaslin, there was a representation that I think it was a backpack that Ms. Kuykendall had taken something out of the hotel room and basically tried to throw it away. And I can't remember if what I was told was, we're still trying to figure out if we can recover that, or it was never recovered, or it was recovered, but I just don't know what's in the backpack. What can you, and I think that was separate from what you described, which is another family member swooping in and taking stuff and leaving with it.
We did a trash pull, Your Honor, at the crime scene for whatever came out of the backpack after reviewing the surveillance footage, and nothing was able to be recovered.
Okay. Just curious. Thank you for sharing that. Ms. Steffo, I want to make sure you've got the last word, and I don't decide bond based on allegations, and this is what the state understands the case is about, and they were providing context, but I definitely understand that bond decisions aren't based on, this sounds like it was particularly serious or not serious, but the relevant IALA factors.
Yes, Your Honor. As to the worry of whether she would report back or not, in regards to the mentioning of the probation warrant or the probation violation, there are several reasons that probation violations are issued. Sometimes they're technical, sometimes they're not. I do believe that she would report. I'm in constant contact with her godmother, and I don't believe that there would be, I apologize, there was office noise. I don't believe that there would be an issue in reporting, and I do think that I also don't think there would be an issue to witness tampering if she's on a 24-hour ankle monitor with only the exception of going to work and medical needs and lawyer meetings. And if you wanted to restrict her from social media, Judge, I think there's plenty of outlets that we could do to resolve that risk and issue that the state has provided to us. But I do think it's important to consider the 3 other children that miss their mom and don't understand why their mom is not there and why they're staying with their grandfather and their godmother currently.
Okay. No, I appreciate that. There are other people in the mix. They're probably also not understanding what happened to their sibling. So there's a lot that's confusing and complicated in their life. Ms. Steffo, last question for you. It has nothing to do with bond. It's more procedure and our ability to stay focused on the case. If and when this gets indicted, it may get assigned to me. It may go to a different judge. But I will have it as long as it's unindicted and there are questions about procedure or bond or anything like that. Are you on this case and are you representing Ms. Kuykendall just to sort out what happens pre-indictment, or will you be her attorney and advocate throughout whatever may follow?
Your Honor, I only handle matters like this up until indictment. I only work in the non-complex division and pre-indictment. So once it's indicted, depending on what courtroom it'll go to, it'll either be a contract C3 attorney or one of the attorneys in my office.
Okay, so just hypothetically, if it was assigned to me, I benefit from Ms. Cabrera being the contract attorney assigned here who handles conflict cases. So in theory, it would be assigned to her. I know you and I don't make that decision, but that's what you're describing to me?
Yes, Your Honor.
Okay, but that's great. I just want to be able to assure Ms. Kuykendall, because it sounds like an indictment is soon to come, that when she is then in a different courtroom and she doesn't see you there, she shouldn't feel like, wait, I'm being abandoned. You're doing everything you can on her behalf, but you naturally would roll off this case and either someone from your office, if it's one courtroom, or one of the, as you call it, contract attorneys would then step in and be in a position to advocate for Ms. Kuykendall.
Yes, Judge. And I do always make sure that my clients are aware that I will only represent them to a certain point, and then they'll be transferred either to the other attorneys in my office or a conflict attorney.
Got it.
Or another
Okay.
C3.
Got it. Thank you so much. Ms. McCauley, I'm going to take you up on your offer to look at some of those text messages, and I'd ask you, in whatever format's easiest for you to share, to get that to Ms. Steffo as well. But I would like to review some of those before I figure out what I'm going to do. But I also want to preview this for Ms. Steffo. If I do set a bond for Ms. Kuykendall, it will have as a condition that she cannot have unsupervised contact with any of her kids. And I am going to need to be real comfortable as to how that's enforced. I don't know whether that means I need to meet the godmother or her father, but I think you can understand why I would be concerned for the general well-being, which is not me saying Ms. Kuykendall isn't similarly concerned, but this is a complicated situation where I think we need to be extra thoughtful about what is best, not just for the short term, as in we miss mom and we're confused, but the long term, as in 10 years from now, we can still want to be spending time with mom because we're still around situation. So that's my largest concern, not that Ms. Kuykendall would disappear, but that we wouldn't have a situation in place where the children are able to interact with their mother, but they are also safe, if that makes sense.
It does, Your Honor, and I do understand. I could arrange for you to meet with her godmother if necessary.
Okay, we'll start with the text messages, and then I'll let folks know how I processed that. Ms. Kuykendall, here's what that means for right now. I'm not setting a bond for you right now. I'm going to review these text messages. They're not evidence in your trial or anything like that, but it's information I'm entitled to consider. Those will go to your lawyer as well. So she'll have a chance to say, wait a minute, this is not even my client's phone number. It's real clear that's Mr. McCaslin talking with his mom. But I will look at those, and I may conclude that no bond is how things should remain, or I may decide that I am going to set a bond. If I do, I will likely take Ms. Steffo up on her offer and see how I can figure out a way to speak with your godmother about what the setting would be like if you were staying with her and you were around your kids. Do you have any questions about what I just described? No? They just muted you. Something's not working over there because I can't hear you. Now I can hear you. Get a little closer to the microphone, please.
No, sir. What if I wasn't in the home with the children?
So that would be different, but there's still and I don't know if Ms. Rivers could hear that. Your question, as I understood it, was, well, what if you're in a home and the children are not there? That on its face would address my concern. But the larger issue is, how do I ensure that you are not around your kids? And that's harder to do. Because you could say, look, I'm staying with my uncle, and the only people who are there are my uncle and his wife and 2 dogs. But people have legs, cars have wheels, and all of a sudden your kids are at your uncle's house. And I haven't done my job to be thinking about what keeps everyone in the community as safe as can be. Not necessarily as happy as can be, but as safe as can be. So I'm wrestling with that because that was going to be my initial response to Ms. Steffo. That's why I asked her, like, wait, is this the same godmother where the kids are? To me, that's a problematic solution. And it may be that I come down with something that's not no bond. It's a bond, but you need to find a place where the kids are not going to be. And a condition of the bond would be you may not be around them.
My kids are with, I have 2 godmothers. My youngest, my 13-year-old, my 1-year-old is with my godmom, and my son is with dad. I would be totally different.
So I didn't hear the last part of what you said. I understand that you have some kids with the godmother.
I believe she said that she would be living, like she could live with her other godmother without the children.
Okay. All right, I will keep that in mind, that there is an option where you wouldn't be living with the kids, but I still have the concern I need to figure out if I'm comfortable solving, where you'd still be out, and that does, no one, I don't have eyes on you 24/7, and so maybe the kids are around, and maybe that's okay, but we're dealing with a situation where on the surface, it appears it was not okay, you being around your kids, and maybe on more than one occasion. So that's what I'm working through. But I've explained what the process will be, and I will certainly let Ms. Steffo and Ms. McCauley know. And the last thing I want to share with you, Ms. Kuykendall, and I've sort of already said it, but I just want to make sure you follow it. In the same way that once your case is indicted, you won't be working with Ms. Steffo anymore. It's probably going to be the case that you'll have a different judge. Your case will be randomly assigned to one of 15 judges. I'm one of those 15. So if it's not assigned to me, then you'd be working with a different judge who has the ability. Let's say I decide yes, bond, but $100,000. I'm making that up, but that's what I do. And that's ridiculous, Judge. I can never post that bond. There'll be a whole nother judge who's going to take a different perspective on things. And he or she would hear from your lawyer who's handling your case from that point forward. And that judge might agree to change something. So I'm going to rule at some point as to whether you should have a bond or not and what that bond should look like. That's not the law of the case forever and ever. My colleague is free to say, McBurney got it wrong. I'm going to do something different. Okay? Ms. Steffo, anything else on behalf of Ms. Kuykendall?
No, Your Honor.
Okay, thank you for your time and for working on the case. Ms. McCauley, I saw an email flash up from you. It sounds like you have already gotten things to me and Ms. Steffo. Thank you for that. Anything else from the state? I'm sorry, we weren't hearing you. It doesn't show you as being on mute.
Not on mute.
Okay, now I can hear you.
Okay, I said I included the specific page numbers for the text messages I referenced during my hearing in the email.
Excellent. Okay. So until indictment, if there's an issue from the state side with the case, reach out to Ms. Nelson. After indictment, we'll see where you land. But thank you again to your office for doing some of Fulton's work. I know you've got plenty of your own.
I still have isn't the other defendant on as well today, Judge, but I'll stay on for that.
No, stay on. I'm not quite sure why he is, but I saw Mr. Cozzoli is here, so we'll talk about that. But I wanted to clear the decks for ACDC first since they had raised their hands. So if there's no one else at ACDC that we're supposed to work with today, thank you, ma'am, for signing on. You guys have a good weekend.
Bye-bye.
Bye-bye. And Ms. Steffo, yes, go ahead.
I was just going to ask if I may be excused.
Yep, we were going to say the same thing. If you don't have anything else on the calendar, thank you again for being here.
Thank you, Judge. You have a great day and a good weekend.
You too.
Financial hardship and housing instability may have limited them to a hotel, so I tread lightly there. But meth and cocaine around children? Absolutely not. She doesn't deserve bond. Even though the judge hinted that any bond would come with strict conditions, including no unsupervised contact with their surviving children, I don't know how I feel about that. What do you think? When the evidence points to deliberate endangerment, should the court even entertain the possibility of release? Let me know your thoughts in the comments. And don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.